Hi, good afternoon, everybody. My name is Susanna Baruch. I'm the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics here at Harvard Law School. The Petrie-Flom Center is a research program dedicated to legal analysis and interdisciplinary scholarship on all the critical questions facing the healthcare field. I invite you to check us out on our website, and while you are there, the website is petrieflom.law.harvard.edu, but it should be easy to find. Please explore our blog, Bill of Health, which gets nearly 1 million views a year, and you can join the 12,000 people who subscribe to our newsletter. But welcome to Hot Topics in Embryo Law and Ethics. This is the kickoff event for this year's annual conference. Tomorrow's Writers' Workshop is for authors only, but it will be live streamed. Again, you can sign up to see it at our website at the QR code that's posted around the room, or just go to our website tomorrow morning and you'll be able to get in. We want to especially thank the Oswald D.N. Kamen Fund at Harvard University and the ASRM Center for Policy and Leadership for their support for this conference. And I also want to thank the extraordinary, unflappable Petrie-Flom staff. Depending how you count, we're on something like our 4th major event in 7 days. So a big thank you to Laura Chong, who's our Financial and Administrative Director, Lisa Gorelick, our Program Coordinator and Digital Specialist, Erin Scott, Communications Manager, and our Postdoctoral Fellow, Sophia Palmieri. Hopefully you met some of these folks on your way in. Today's event will be moderated by Glenn Cohen, the James A. Atwood and Leslie William Professor and Deputy Dean here at Harvard Law School, as well as the Petrie-Flom Center's Faculty Director. We are joined by a remarkable expert panel, and as well as our 2 esteemed co-editors and co-organizers of this conference who will be serving as respondents to the panel. I will turn it over to Glenn. Let me say one word before I do. This is my fun job. Our favorite thing on earth is the timer box. This is the way that we ensure that people keep their comments to the agreed upon amount of time, so we have time for discussion at the end. You'll see a green light when each speaker begins talking. It will turn to yellow with 1 minute remaining. It will then turn to red. We could set it to beep and flash, but we don't do that. But when it does turn red, you have our permission to gently rustle papers and kind of indicate that the person's time is up. We do it in the friendliest possible way, kind of a crowdsourcing of timekeeping. So with that, I will turn it over to Glenn.
And a big thank you to Susanna Baruch. We do have a couple seats right up front. Funnily, my students never like sitting up front either. I don't know what that's about, but anyways, you're welcome to one of these seats. Well, hello everybody, I'm Glenn Cohen. It's really a pleasure to have you here today. The focus tonight is going to be on 2 of the hottest topics in embryo law and ethics. I like to say tomorrow will be scholarly, inventive, interesting, and tonight's fireworks. That's what we want. We've invited people who are going to bring intellectual fireworks, and you're not going to be disappointed at all. Tomorrow will be exciting too, don't get me wrong, and you can watch it on the live stream, right? But today it's going to be that kind of thing. So in particular, though, I want to acknowledge 2 people who are really important for today and tomorrow happening, and that is, along with Susanna and I, our 2 co-editors on the book who are here today and are going to be respondents to the panel today. One is Judy Darr, who's the Ambassador Patricia L. Herbal Dean and Professor of Law at Northern Kentucky University Chase College of Law, and the other is O. Carter Sneed, the Charles E. Rice Professor of Law and concurrent Professor of Political Science at the University of Notre Dame. Big round of applause for them. Now for the main event. A very brief introduction to our panelists. You can find much more about them through the links on our website. And we're kind of dividing the conversation, I would say, into 2 chunks. The first chunk will be about legal and ethical issues surrounding the estimated over 1 million frozen embryos in the United States, particularly issues regarding long frozen or so-called abandoned embryos and disputes over their fate. And on this, we're going to hear from two great panelists, from Leslie Meltzer-Henry, who's a professor of law at the University of Maryland Francis King Carey School of Law, but who also holds a faculty appointment at the Johns Hopkins Berman Institute of Bioethics, and Julia Hesse, who's a partner at Holland and Knight and a member also of the Petrie-Flom Center's advisory board. In the second portion of tonight, we're going to explore questions about lab-grown structures created from pluripotent stem cells, mimicking the early development of embryos, including whether they should be legally regulated in the same way as quote-unquote ordinary human embryos. And on this, we're going to hear from Antonio Regalado, who's the senior editor of biomedicine at the MIT Technology Review, and Insoo Hyun, who's director of the Center for Life Science and Public Learning at the Museum of Science of Boston, as well as being a fellow at the Hastings Center for Bioethics and an affiliate of the HMS, Harvard Medical School Center for Bioethics. You heard about our friend, this 1980s technology, the green, yellow, red light. We're going to try to keep people mostly to time, and they're each going to have about 5 minutes of remarks. Essentially, the idea is a kind of spark talk to get us started. That's going to leave significant amount of time for question and answer, so I invite you, as you're hearing things, ideas, questions, comments you want to share. And with that, I'm going to turn it over to Leslie. Yeah, we'll get you a clicker ready. And do you want to come up here? Will that
Yeah,
be
that
easier
would
for
be
you?
great.
That's great. And we will sit here contemplatively, imagining what the amazing slides are, but we'll enjoy it.
It's just this button. Yes, next. Okay, perfect. So thank you to the Petrie-Flom Center for organizing and hosting this event and for the opportunity to be in dialogue with my terrific co-panelists and all of you today. I only have 5 minutes, as you now know, and it's me against this red light. So let me start with a brief introduction to the project that brings me to this work. I am a member of the Bioethics Legislative Opportunities, Outcomes, and Models Initiative, or BLOOM for short, a multidisciplinary group at the Johns Hopkins Berman Institute of Bioethics. The BLOOM project was created to identify areas where legal and ethical challenges are outpacing existing governance frameworks. Cryopreserved embryo disposition quickly emerged as a priority for us because it sits at the intersection of several converging trends: the widespread success of in vitro fertilization, the accumulation of a large and growing number of cryopreserved embryos in long-term storage, the increasing movement of patients and embryos across state lines, and a rapidly evolving legal landscape. To give you a sense of the legal terrain, since 1980, more than 500 legal cases involving control of frozen embryos have been filed in state courts. These disputes typically arise when embryos created through IVF and stored for future use become the subject of disagreement following changes in the circumstances or the preferences of intended parents. That could include divorce, separation, death, incapacity of intended parents, differing views regarding reproduction. And although the highest courts of 9 states have addressed such disputes, there is not a consistent legal standard that has emerged to govern decision-making authority over these embryos. The resulting lack of uniformity has produced what can really only be described as a fragmented legal landscape that contributes to costly, emotional, and protracted litigation that has left both intended parents and fertility providers without clear guidance. What made this issue particularly compelling to our initiative is that despite the frequency with which clinics and patients confront these issues, there has not yet been resolution or comprehensive frameworks for addressing them. Existing law has tended to be piecemeal through individual disputes, isolated statutes, or clinic-specific policies. Here you can see our core project team, our terrific research assistants, and we also have a terrific board of experts representing a broad range of expertise and viewpoints. Our objective was to create model state legislation for the disposition of cryopreserved embryos, but to do so not in a way that eliminated disagreement, but in a way that was informed by the practical realities of fertility care, the ethical complexity of embryo disposition, and the institutional challenges facing stakeholders. Here you can see the prevalence of the legal disputes I described. They reflect this, in part, continued growth of in vitro fertilization in the US over 4 decades. You'll see in the last year, more than 100,000 births came through in vitro fertilization nationwide. Many of you know that the in vitro fertilization process typically creates more embryos than are used in any single attempt, leading to a large number, anywhere estimated between 400,000 beginning in 2002 and as many as 5 million in 2025 of cryopreserved embryos. Most of these embryos are not actually the subject of controversy. They're being stored pursuant to active decisions by the individuals who created them. But over time, we know that circumstances change, as I've given you some sense of what those are. But in other cases, intended parents may become unreachable. They may stop paying storage fees, clinics close, embryos are relocated, patients move across state lines, and directives that were drafted years ago may no longer reflect current preferences. Here is the growing governance challenge. Many of, and I see my time kind of winding down, many of those challenges coming about and being exacerbated or more complicated in recent years in the post-ops landscape, and as a number of states have or are moving toward personhood-oriented language and their statutes or constitutional provisions defining the unborn child or person in ways that, depending on how courts read them, may not simply be limited to pregnancy and could, in fact, extend to embryos outside the womb. The clearest example of that would be the LePage case. I am going to give you just a sense of what we aim to do in the last couple of minutes, and that is a couple of seconds, I think, 10 to be exact. What we aim to do was to provide an act grounded in a single core principle, and that's that advance directives specifying disposition instructions for reasonably foreseeable circumstances provide the most reliable means of respecting the autonomy and preferences of intended parents. Documented in advance before a dispute arises, those directives let people make considered prospective decisions about deeply personal matters rather than leaving those decisions to be reconstructed after the fact, often in litigation. And as you can see here, our goals, I'm going to let you look rather than me speak so that we can get to the other speakers. But here you can see not just what our grounding principle was, but also what our framework aims to offer. And hopefully during the Q&A, we'll be able to talk more about the act itself.
Thank you very much. Big round of applause. Now, at the Petrie Flom Center, we don't stand on ceremony, and neither do you have to. There are 2 or 3 seats up here in the front. There's one over here, and if someone else has a free seat, just raise your hand if there's a seat happens to be next to you. All right, we're now going to move on to our next speaker. You can sit, you can stand, whatever you prefer.
I'm going to sit because I did not prepare slides. My name's Julia Hesse. I'm a practicing lawyer. I represent a number of fertility platforms, so large national and international companies that provide fertility services. And usually they put the practitioner at the end because we talk about only like the sexiest stuff like insurance. And so I would please like to talk to you about the insurance, like the property insurance side, the operational side of running a fertility clinic, which has become increasingly challenging with the number of embryos in long-term storage and with the embryo personhood laws that have been passed or attempted to have been passed. So if you think big picture, we all know, and we've known for a long time, that embryos have this quasi-property designation under the laws of most states, and this is all case law. So they are property where people can have a contract and can decide between them what happens in the disposition of those embryos. At the same time, they're special property. And they're special property that can't be sold and often is very difficult to destroy. And when accidents happen and say embryos are destroyed unintentionally, like there's a tank failure, the value of that property is often in the person who has lost that tissue greatly exceeds the amount that that tissue can be insured for, right? So for example, if in the typical med mal market, if we were all ripped limb from limb in a horrible accident, the world has settled on a value of an actual human life. And it's generally speaking somewhere between $250,000 and $1 million. And often it's a lot lower than that because it depends on how old are you and how sick are you. But there's a process in many states when the value of that human life in traditional med mal got too large, implemented tort reform to say, ooh, well, there wouldn't be any doctors if people were able to sue them until the end of the earth. That has not yet happened in the fertility market. And so when embryos are accidentally destroyed, the claimants come forward and they say, well, this was my dream. This was my dream of a family, and you can't put a price on that. But you can't operate a business where the liability is unlimited, but the amount that they're charging for long-term storage is $500 a year, $1,000 a year, so there's a big mismatch. So I would advocate that for the model legislation, a piece of that would include some type of either tort reform to say the maximum damages for loss of an embryo or inadvertent destruction of tissue could be X, right? Whatever the X would be, but it would be aligned with state laws related to the loss of a human life. I would also advocate for there being, as there is in some countries in Europe, a maximum duration of time that tissue could be stored. Because a lot of people, and it's not just anecdotal, I think that the numbers of cases that exist reported cases vastly undercount the number of disputes that actually exist between patients and their fertility clinics or between and among patients and their partners related to embryo disposition. But there are a lot of patients that have a dream of having a family and they pay for putting their embryos in storage and then they just stop. And they don't want to tell anybody to destroy their embryos, but they really don't want to tell them to keep paying forever, and they know they're not gonna have a family. And so the clinics are there, and there are policies, and ASRM does allow that after a certain amount of time of lost contact, whomever is storing the tissue could dispose of the tissue without getting affirmative consent of the person. But it would be easier to do that. I don't know any provider that is excited to be the first one going out and publicizing the fact that your embryos are only gonna be here for 10 years and after that we're destroying every single one of them. Nobody wants to be that company, but if the law said you could only maintain tissue for this period of time, that would make the market easier because that number of 1 million embryos is growing quite large, very quickly, and the number of people that are making those considered dispositional decisions, a lot of people give up on that dispositional control when the rubber meets the road. So, I'll cede my 17 seconds over to the next person.
We'll give it back to your Q&A. Big round of applause.
Yeah.
Antonio, I think you're next up.
I am. Could you lower your screen so I can see the timer?
Of course.
Because I practiced these remarks and I'm way over. Okay. Insu and I are supposed to talk about human embryo models or synthetic embryos. And I will use 20 seconds of my time to just say what they are. About 16 years ago, scientists observed that they took embryonic stem cells taken from embryos and cultivated in the lab, and they put them into a particular shape, often like an inverted pyramid or something, maybe added a couple of signals. These cells would start to try and organize into an embryo or into parts of an embryo, right? So now you're taking stem cells and somehow they're trying to act out their program of creating a body, and if you guide them in the right way, they'll actually start to do so. So this is the synthetic embryo model. Now, they're not embryos, right? Because they're partial or they're not normal, but also they're not embryos by decree, because the leading society has said these are not and will not ever be true embryos. And why do they say that? Well, that's good, because then you don't have to deal with the laws and the ethics of real embryos. And the synthetic embryo is kind of useful because it's a model of the embryo, like 10 to 30 days or something. When it's usually in the womb and very small, you never see it. And if it's in the lab, you can genetically modify it. You can knock genes in and knock genes out and put reporters in and make them glow. And you can start to understand biology. But the key thing would be, don't let them become real embryos. And so that brings me to the second half of my remarks, which is about a profile we did of a scientist who seems on the pathway to do exactly that. And his name is Jacob Hanna. He's from Israel. He's a very interesting character in a number of ways, which made him a great profile subject. He was kind of reluctant to be profiled by me. In fact, he said, no, and everything I've ever said to you is off the record now. And why is that? He doesn't like the vivid or maybe even the lurid way I describe what he's trying to do. And what is he trying to do? Well, he's trying to grow these synthetic embryo models, and his are very realistic, right? They have all the parts of an embryo. 20 days, 40 days, even 70 days. So I know how to look up what a 70-day human embryo looks like, and that's actually a fetus, right? It has little hands and little feet and a little face. And, what is the reaction of the public going to be? He grows them in sort of rotating bottles. You have this little rotating bottle, and then there's a little tiny human being in there. Like, that is going to freak people out, I think. Or it should. Or maybe in this day and age, it won't, and people will just accept it as part of science and advancement of technology. He's got a company, and the company intends to grow these human embryo models to get useful tissues, right? Around 40 days arises the blood system, the hematopoietic system. So instead of getting a bone marrow transplant, why not produce a bunch of little synthetic human embryo models to get these cells from? And in fact, they're your clones, right? Because it starts with a skin cell that they turn into a stem cell, that they turn into a synthetic embryo. So it's like thousands of little clones of you that you'd be harvesting tissues of. And now you can see why Jacob Hanna is annoyed with me, because I like to talk about mini-me's and clones in the laboratory. But I think that's exactly what they are. 70 days, well, that is when the sort of primitive ovary forms. So consider that. You're too old to have a child, but you could get yourself cloned into one of these structures, and then you could harvest the fetal gonad from it. This is part of their business plan. So I also think that that is worth paying attention to. Ultimately, this research is intersecting with sort of longevity science. There's people who very aggressively want to live forever, and they have a lot of money from crypto and different things. These are billionaires, and they're darn serious about not dying. And having a cloned body of yourself is like their top fix, right? Head transplant. Get your head put on the young body. So as crazy as it sounds, these little tiny clones that are growing in the laboratory, some people would like to take them all the way to birth. So I will also cede 25 seconds to Insu.
Thank you very much.
I don't know, let me stand up. That's okay.
Let's first get a round of applause for. All right. Go ahead,
Well,
Insu. Yeah.
Glenn, you wanted fireworks, so you got some right
Yeah.
there from Antonio. Hey, it's a pleasure to be here. I wanted to stand because I wanted to see people as I speak. So I'm going to answer the question, what do I find interesting about stem cell-based embryo models? And for that, I want to give you a little bit of history, because I think what's fascinating to me is that the scientific and ethical issues that are arising are sort of, I like to say, what's old is new again. It's kind of like this idea of renewal of the themes, renewal of the cell lines, renewal of life. So I got my PhD in philosophy in 1998. That was the same year that Jamie Thomson derived human embryonic stem cells. And the human embryonic stem cell debate launched into full force. That was the year after Ian Wilmot announced cloning of Dolly the sheep. Then you start to get a really interesting interaction of the idea of, we have human embryonic stem cells, why don't we mix it with cloning technology? You can get patient-specific stem cells where you can get, cell donor, get your cloned embryo, and you can get stem cells directly matched to that. So this idea of like rejuvenation and kind of renewal of your own cells without any fear of rejection kind of came into being at that time. And then, of course, after all that controversy started, induced pluripotent stem cells came on the scene in, 2006, 2007. And that's where you don't need cloning to get patient-specific stem cells or matched stem cells. You can just get a somatic cell, reprogram it into an embryonic stem cell-like state, and then do everything that human embryonic stem cells can do from that point forward. And when that innovation happened, people would come up to me and they say, oh, Professor Chen, I guess you have nothing more to work on in stem cell ethics because we can bypass the embryo and just go right with, so-called, adult-derived pluripotent stem cells. And I said, just you wait. We'll see, right? And what I find fascinating is now the usual cell type that they use for these embryo models are these induced pluripotent stem cells, which in many cases have a living donor that coexists with that stem cell line. Some of these living donors there were pediatric patients at the time in which you derive the cell line. So you have people who might coexist with the cell line, and then if you're doing research on embryo models, there's the whole question of, do you need to go back and get consent from these people? So why am I saying this is interesting? I want to say that there are two main types of stem cell models. Well, actually, there are four main types. So the first rough cut you need to think about is you might model pre-implantation stage embryos. So these are the embryos that you have in the fertility clinic after you unite sperm and egg and right before implantation. So right around day 4 or 5, that's the blastocyst stage. You can make models at the blastocyst stage called blastoids. You could also model, people think, embryo development after implantation. Okay, so this is way beyond what we can normally study with natural human embryos, and that could represent, the formation of different organ systems, more specialization, et cetera. People have asked me, am I worried about kind of the return of the reproductive cloning debate? Because remember, we kind of started with that interesting mix, and it seems to me that we are possibly entering into that field again. Antonia had very provocatively suggested that that's where we're heading. I want to point out two things right now about the limitations of scientifically why we're not likely to get reproductive embryo model work going on. One is the pre-implantation work, the blastoids. In order to get those, you have to reprogram the cells back to a very, very early state called naive state stem cells. So normally stem cells come in what's called a prime state for the human, which is a little bit further along in development. You have to actually get back to what's called the naive state to get the blastoids. To do the naive state, you have to, this is scientifically a little complicated, but you have to erase the parental imprinting to get to the blastoid state, which means after the blastoid state, it's going to be very hard for these things to go on any further because you've erased the cues that they need for normal development. So until they can make blastoids without naive cells, you're developmentally limited there. The post-implantation stages, assuming that they are accurate, we don't know because there's no natural embryo to compare them to. Assuming that they are accurate, you can't just simply take what's in culture and implant it into a uterus without having it be prepared to accept that. So there's implantation failure, I think. Now, Antonio thinks maybe there's a way to work around that. But right now, the current state of the science is you have these models. Some of them are more complete than others. I've never seen one that was complete. Even the blastoids, those are spatially a little bit irregular. They have unknown cell types that are in there, so they're not actually identical to the blastocyst. So just think of those two dimensions, before implantation, after implantation, and how complete is the model. You can do a lot of really wonderful science in any of those quadrants without necessarily raising the threat of human cloning, but the threat is kind of lingering there, okay? So that's what I find interesting is things are kind of going back to the beginning in a way, and the tool of the trade are iPS cells. Thank you.
Thank you. So before we get to Q&A, we're going to have two brief respondent. And Carter, I'm going to let you be the first one. If you want to come up here.
Sure. I'm going to be very brief because I'm most interested in the conversation that we're going to have with our wonderful panelists and our great audience. Thank you all for joining us. Thank you, Judy and Suzanne and Glenn. Just two very brief comments about these very rich and concise presentations. On the question involving cryostorage of embryos and hearing about the very interesting model statute project and also the tort reform proposals that were discussed, when I'm a law professor, so what do you try to teach our law students? When you're analyzing a law or a policy, the first question you want to ask is not so much the doctrinal mechanisms of how it works, but rather the fundamental question of what is the law meaning to do? What is the good that it's meaning to advance? What harms are we trying to avoid? What goods are we trying to promote? And I'm interested to know more about on that level of analysis of the two separate proposals, but related proposals that we heard from. Back in 2003, and the Hoffman study was referenced, Rand Corporation did an exhaustive study of how many embryos in cryostorage there are in the United States. They looked at all of the disposition forms, and I think they might have even interviewed patients who talked about their intentions and their views about what they were thinking. And when the President's Council on Bioethics, which I served as general counsel from 2002 to 2005, produced a report in which we talked to a lot of different patients' rights groups, including the American Fertility Association, originally called the American Infertility Association. We talked to Pam Madsen about their members and how they thought about these embryos that were in cryostorage. And what we learned from our conversations with them and from the social science evidence that I've just talked about is that people are unsurprisingly incredibly ambivalent about the embryos that they have in cryostorage. They feel attached to them. They represent the future that they had hoped for. And it's an interesting, even Steptoe and Edwards talking about Louise Brown said, I saw Louise Brown in the Petri dish, and I saw her when she was born, and she was beautiful then, and she's beautiful now, just to elicit the kind of ambivalence that people feel about these things. And so one of the things that I would be concerned about or would want to focus on is how are we advancing the autonomy and self-determination of these patients? And how do we capture the ambivalence and respect that ambivalence in a way that doesn't override that in the name of other goods such as efficiency or economic considerations and so on. And obviously there has to be a balance, there has to be limits. But that's just one thing that immediately occurred to me is when we're thinking about orienting ourselves towards what goods we want to advance, in that particular domain, I would want to focus on how to advance the goods of patients and their interests, and to try to, and the extraordinary complexity and even internal incoherence sometimes about how people feel about the embryos that they have in cryostorage. Just one quick thought, and then the 13 seconds I have remaining, I think the fundamental question around synthetic embryos is the question of what an organism is. Are these models merely aggregates of cells that have limited developmental trajectories, or are they disabled organisms? And I'll stop there. Thank you.
I'll now invite up Dean Dar.
Good afternoon. Hello, everyone, and thank you so much for including me in this. It's a thrill to be here, and I'll keep this very brief. On the embryo disposition front, thinking about what you were going to speak about today, I was curious to know your views on the impact that Dobbs has had in this area. When Dobbs was decided now almost 4 years ago, those of us in the field worried about its impact on IVF, mostly standard of care practice. Would the Dobbs decision restrict the ability to discard or to cryopreserve or to operate in a pre-implantation genetic testing model and other very traditional, what I would call standard of care aspects of IVF treatment? And we actually haven't really seen that to date, not in a robust way. There have been some modest attempts to limit access to standard of care, but that's not what's happened. What's happened is really more in the field that you're discussing. There have been a lot more pivots in the world of embryo disposition, thanks to, I would say, Dobbs than we've seen in standard of care practice. And we'll read a paper tomorrow which documents some of the recent cases involving disposition disagreements in which, and again, I'm going to use some generalizations, they're very gendered in the way that they produce at the court level. Typically, the male who did contribute the sperm does not want to proceed in the event of a divorce or in the aspect of a divorce, and the woman, who often is the egg donor, not always, does want to have possession of the embryos. And what we're seeing is, prior to Dobbs, it was not always, but quite often the case that the courts would favor the person who wanted to avoid procreation. But in the wake of Dobbs, which some describe as a state-forced birth or forced procreation, we're seeing a shift in the courts to award those embryos to the person who wants to use them. That is essentially to deprive someone of the right to not become a parent, to avoid procreation. So I'd love to hear from the panelists about whether you think Dobbs has really moved you in that direction. And Leslie, I'll just mention I am on the board for Bloom, and when we first discussed this probably over a year ago, I was struck, and I know I said it at the time, by one of the provisions in the proposed statute that does allow the intended parents who wants to bring the embryo to birth to be favored in some context. I thought that was, at the time, really interesting, and in the wake of Dobbs, even more interesting today. Insu and Antonio, as a lawyer, I'm really limited in what I can do and what I can say and what I can think. So your papers made me think about the two traditional aspects of law, that is language and status. And I know there's been a lot of discussion about the language in particular. Antonio, you refer to these entities as synthetic embryos, but I know others have objected to that language, saying there's nothing synthetic about them. They're not derived from any raw materials that are not found in nature, and they're not embryos because, as you explained, the organizational patterns don't represent or mimic those of embryos. So I'm curious to hear your thoughts on this idea of language. And then finally, status. I mean, that's what I think is really generating the most interest. Are these embryos, should they be regarded as humans and subject to the same human subject regulations, and et cetera, or are they different? And I'll just leave with one final thought. This debate today takes me back to 1978, even prior to the birth of Louise Brown, when the thought of someone being born in an asexual manner was just absolutely striking. And we had this moral panic over IVF. There was a lot of writing about, will this person really be a person? Will there be a post-human future because of IVF? And this current debate really takes me back to that, where we're looking at a different way to possibly create a human being. And we might be guided by the principles of the product and the capacity of that entity rather than its origin. So thank you so much.
So now we're ready for questions from all of you. We have two friends with a microphone that'll bring it over. I will say we are looking for questions. What characterizes a question in my book is that it's short and to the point. That's one thing. And second, it ends with like an intonation like, oh. And if you fail one or both criteria, I will cut you off. So I think there is a question right up here.
Thank you. Emma Waters from the Heritage Foundation. For you, Antonio, I wanted to further Carter's original question regarding the synthetic human embryo and the difference between a disabled organism and how you would potentially define it yourself. And I would love to hear the differences in how that's categorized typically.
Well, the word disabled is even too lurid and charged for me to use. I'm not using disabled, but it's true. In creating these synthetic embryos, you have this question, is it going to be a real embryo somehow? But the scientists' answer to that is like, oh, that's easy peasy. We'll just use CRISPR and we'll do a gene knockout and we'll develop a brain. So there is disengineering. There is disenhancement, which is strange to think about because usually we're talking about super babies. Like tomorrow, I'm sure there's a super baby discussion. But here it's less than, right? It is a diminished thing intentionally so that it's not human. I don't know if that answers your question, but I was real excited to say that, and I kind of forgot what the question was.
That's pretty good. I will say tomorrow we have 2 or 3 papers on exactly this topic, including the question also about whether history matters. Does it matter how it comes about? And then I think also responds a little bit to what Carter said, but also Antonio, this idea also about our reactions emotionally and whether the fact that when we see something, as you say, 70 days in a bottle, the fact that we have one particular reaction, is that a guide to us morally or not? I think I saw another question. Do we already have one? Okay. Let's go up here, sir. You in the very fun shirt over there. That is you, Chris. I'm just making a little fun of your expense.
I think he knows my name, so not to be coy.
It's a fun shirt. Okay.
This is Chris Robertson, and I was interested in the legislative reform and tort questions, and how much is there really what professors would call a market failure in the, I mean, you have sophisticated parties on both sides of these deals, more or less, and so why haven't the clinics solved some of these problems through contracting by specifying embryo disposition or eliciting the preferences of the parents? What are the real barriers here to the clinicians and the embryo contributors making the right choice? Upwards intonation.
Yeah, well, I mean, from my perspective as a practitioner, I don't think it's a failure of people, of either the clinics or the patients being solicited their preferences and their consent. I think that that does happen and has happened. There's a really broad consent process that does take into account people's and request people's information about what they want for dispositional control. So that happens. I think what also happens is people change their mind. People have the ambivalence that was discussed before. And at the end of the day, people just don't, when it comes time to make a final choice, what we're seeing in practice is people don't want to choose a final choice. And maybe, meaning that when it comes time to either stop paying for storage and do something different with their embryos, they just disappear and they don't want to have someone choose that. And then on the market piece, like there's a secondary piece of these are sophisticated parties. We've got people way less sophisticated than companies. And then you've got third-party insurance companies that so that's where there's truly two sophisticated parties, where you have a fertility provider and their insurance company standing in the background. And there, I think there's quite a mismatch because the amount of insurance that insurance companies are willing to provide to support a fertility company substantially below the risk of operating one of these companies when you've got hundreds, thousands of embryos in one single cryo storage tank. The risk of even one tank failing greatly exceeds what the current market is for insurance. And so that's and the risk there is quite real that insurance companies are backing out of the market. So the ability for a company to obtain insurance at the current market is becoming limited.
I saw a question in the back row right over there.
That's okay.
I'm sorry, do you want to jump in? I'm sorry, one sec, though. You go ahead, Leslie, I didn't see your hand.
I'll just jump in real quickly. I think there's a nuts and bolts answer to your question and a more philosophical answer. And the nuts and bolts answer I only learned about by the Bloom Project, meeting with a lot of people who actually work in these fertility clinics as physicians and some prior patients. And what we learned is that there's three things that happen when they are signing a so-called contract. One is that they're signing for retrieval or potentially donation from a third party. Two, they are signing a contract for storage. And three, they're making a disposition arrangement or choice. And those three things are all wrapped together frequently in a set of documents that they're given and told to often take home without very much conversation from the facility itself. And sometimes called a contract, all three pieces together. It's sometimes called a clinical informed consent document. But I think the fact of the matter is we're not really clear what it is. And these things probably ought to be disentangled. And one of the things that the model law does is disentangle the clinical component and the storage component from the disposition decision. And by bracketing the disposition decision, you then have a more philosophical conversation about autonomy that arises that I think Carter was signaling. And the philosophical decision then is the decision that you make at that moment when you are about to store embryos, the decision that you are likely to make 10 years later. And what we find is that a lot of people don't want to make a decision 10 years later, and that there is some cognitive dissonance about those embryos and that decisions do change over time. And I think Carter raises an interesting point about how we actually ensure that we are recognizing people's autonomy. One of the things the Act does is require, just like you would with any kind of advanced directive or living will, this is kind of our model here, some rethinking at periodic moments in time. So when you pay your storage fee each year, you should reevaluate the disposition decisions that you make. Things like that, I think, can correct some of the decisions, but clarity about what patients are actually signing goes a long way too.
Great. Yes, sir.
Doug Fox from San Diego. In decisions about what to do with embryos and how we govern their storage, to what extent, if any, should it matter whether people are genetically connected in some way to those embryos?
Sorry. So I think that from the practical perspective, currently for clinics, there's zero relationship to whether or not they're genetically related. So long you could have donor tissue for both sperm and egg, creating an embryo being completely genetically unrelated from the person for whom that is the intended parent, and their control over disposition does not change at all. I think to the point made earlier, though, I agree that post-Dobbs, the case law that has been coming out has been favoring the person, if there is a dispute, has been favoring the person who wishes to have the child be used for, or the embryo be used for reproductive purposes, even when it's clear that the other party has revoked their consent. So the concern that I have is when you do have someone that's genetically related to that tissue, and one of those people says, I do not wish for this tissue to be used for reproductive purposes anymore, that we're finding courts overruling that and saying, even though it is your religious tradition that you need to be an involved parent, the court will terminate your parental rights today before you begin and take away, even when you're genetically related. It's very fascinating and evolving very quickly.
Great. We have some more questions? Let's go over here in the front, and then we'll get you next, sir. And then we'll move our way back.
Thank you. Daniel Statmauer. I'm an embryologist.
A little bit louder if you don't mind, Daniel.
I said I'm Daniel Statmauer. I'm an embryologist. I'm curious about embryo selection and overproduction. That my understanding is that a large portion of the unused embryos is not producing one and then implanting one, but maybe making 5, 10, 20, and then doing a pre-implantation testing of which one is the healthiest, or even more involved testing. And in those cases where it's not someone is ambivalent on whether they want a child or not, but maybe they've used their favorite of the prospective embryos and there are 19 left, are there dispositional issues differ in whether, in rules about whether it is allowed to hedge bets in that way with the overproduction?
So at least in the model law, we don't discuss that specifically. It would be open, as the law is currently constructed, for each state to make decisions about that. And I suspect some more conservative-leaning states would make a different decision than a more liberal-leaning state on that point.
And we found, at the state law level, some states, I think including recently Florida in the last session, attempted to put in place a law that would require essentially a single embryo to be created at a time to address that issue. Challenge with that, and I think the clinicians at the table would say, like, that's not the natural process of embryo creation beginning. There's a funnel that goes down. And so, you for the person who actually has to go through the rigors of producing eggs, I don't think that I would advocate for a woman serially having to produce a single, and it's horribly rigorous for that person. So I think it's not consistent with the actual science to require the single embryo creation. But I agree with Leslie that in current practice, there's no difference in the consents I'm seeing or in the policies that say you can only create X number of, that there's a maximum number that people are creating.
We'll give you the next question, but while the microphone makes its way, I'm going to sneak one in, which is to say, to Antonio and Insu, imagine someone were to say to you, advise me with your best bioethics judgment or public policy judgment on a red line involving manipulations to synthetic embryos or whatever you want to call it, that are not going to be implanted. So we're going to take as a agreed upon, these are never going to be implanted for embryonic use. What would be going too far and why, from your perspective, in terms of alterations or creations of these kinds of structures? We'll get your question one sec. We'll get their answer first.
Okay, red line, okay. I think for me, it really depends on how complete the model is. I've tried to, in my writing, give advice to embryo modelers, and Antonio said, well, a lot of people don't listen to you, and so like, yeah, that's true. What I've said is, to answer your scientific question, there may be no need to have an embryo model do everything. Just model the part you're interested in studying, and there will be no ambiguity in the law and funding for federal funding for the work that you want to do. But I think a lot of people they're very gung-ho trying to make these as complete as possible. So for me, the red line is if it's complete as possible and put into an advanced system, my red line would be that it's shouldn't be used for things that you can't do with natural embryos. I think that it's too much of a workaround around the current policy. But I don't know, you probably have a different red line.
I mean, I'm willing to move my red lines depending on like the news occasion. But let me, I have here printed out a red line that somebody else established. The United States Senate and House passed unanimously the Fetus Farming Prohibition Act of 2006, little known. Okay, what does it do? It prohibits the farming of fetuses. You cannot create you cannot acquire, receive, or accept a donation of human fetal tissue knowing that a human pregnancy was deliberately initiated to provide such tissue. And of course, they knew people might do weird things in the future, so the point two is, if you grow it in an animal, the human in an animal, that's also prohibited. But they didn't have the foresight to ask if it's gonna grow in a bottle. And by his own account, Jacob Hanna would like to get it to the synthetic embryo to the point of being a fetus. So I don't know if this law covers it because it doesn't have artificial womb in it. It's talking about a human pregnancy. Is it already illegal to do in the United States?
Yes, please.
All right. Thank you very much for the presentation. I just wanted to ask, in the model law that was shown during the first presentation, could you go a bit more in depth on how the law changes and streamlines the decision-making process in regards to choosing what to do with, fetuses where the situation has changed surrounding the embryo?
So it's going to be hard to answer very quickly, so I did bring a few examples for you. The Act really tries to build in choice points for different states so that we get some uniformity across states and some harmonization while also allowing states that have different political perspectives or even moral perspectives on some of these questions to make their own decisions. So there are built-in choice points. One of the disposition options, for example, a state can choose a version that includes donation for research and discard among the available choices if, in fact, the embryos are left for 10 years or there is storage without payment for some period of time. These are decisions that a state can decide are permissible or impermissible for the clinic or biobank to make. That is, a state can prohibit donation of sometimes called abandoned or unclaimed embryos. They can prohibit discard. That's one example. There's other examples too, some that might be harder to square with personhood-oriented statutes. How you might handle, for example, an embryo after a certain period of time. I think Judy gave an example of whether you should build in a certain number of years after which, even if payment is being made, a state should allow embryos to be, for example, discarded or donated for research. So these choice points turn out to be, I think, important in trying to get harmonization across states. But the key is to really get the disposition agreement, that directive, created.
Great, let's get some more questions. I think I see, yes, Mr. King back here. What's your microphone?
Intent is doing an awful lot of work here. And so I'm interested in what anybody has to say about whether it really can. The intent to procreate, the intent not to procreate, the intent to do research versus the intent to implant. Why are we saying, just say some more about whether intent can do all that work.
That's for anybody who wants to jump in on that one.
I'll chime in a little bit. Nancy. So great question. So the intent people try to use the intent to draw lines in the cloning debate, right? So people say it's reproductive cloning. We're not talking about that. We're talking about research cloning or just cloning in addition. It's not going to go into a uterus. Similar with embryo models, some people say, these should never go into a human or non-human uterus for reproductive attempts. So intent does seem to matter quite a bit. I'm a little mixed on kind of how much work that could actually do, because I think from a metaphysical kind of philosophical point of view, why should the intent of what's going on in people's minds when they unite sperm and egg have any kind of bearing on what the moral status of that thing is at this exact same stage that you're comparing to, two cases. So that doesn't make a whole lot of sense to me unless you add on top of that kind of a progressive kind of a view, progression view of moral status, where it's only after implantation, when it goes further into development, that you start to accrue moral status. So if there's no intent to add on that social choice element and kind of like the developmental opportunity element of it, then maybe the intent argument actually does work pretty well. But in terms of, yeah, I mean, we're seeing the similar kind of attempts to like say, well, we're gonna draw the line. You asked earlier, I should have said, well, one of my lines is the uterus. Like, don't put the embryo model into a human or non-human uterus, because that's really showing an intent to use the model, not to be a model, but to be something else, to be a life. So it kind of depends on what you think about moral status, where it comes from. Is it just uniting sperm and egg? And you have it from the very beginning, in which case I don't see how what's going on in the person's head makes any difference. Or you have kind of more of a progressivist view of moral status. Then I think intent matters.
Great. I think I saw a question. Yes, please. And we'll go to you afterwards.
Hi, my name is Maureen Kondik. I'm also an embryologist. I don't know how we got two of us within near proximity, but it happened. But I'm actually curious about potential industrial applications of synthetic embryos, and perhaps more likely embryos produced from in vitro gametogenesis, where there are many lower hurdles. The hurdles are lower, and so the likelihood of success is higher. Would any of you care to comment on how you would feel about the generation of hundreds of billions of developing humans for use in industrial drug testing, development, and manufacture?
I can make one comment just about how it's already being done. Like these labs that are the experts in human embryo models, there's just a few at the top. They've each seemingly spun out a company. I mentioned Jacob Hanna's trying to make cells and tissues, but the other ones are much more oriented towards IVF, right? Because if you have this blastoid, which is a kind of ersatz blastocyst, it comes from the patient, and then you can see if it implants on some kind of endometrial tissue that might also be from the patient, or an organoid. And so it's sort of, the way it's being industrialized is like, we're gonna study implantation in a kind of personalized, I wouldn't exactly call it industrial yet, but we're gonna do these tests. And so that is actually how it's being commercialized. Personal insight into whether there's a cause of your implantation failure. They can't tell you the cause, but they might be able to diagnose, yeah, this is what's stopping you from getting pregnant. And so that's a practical use of these synthetic embryo models that's happening already.
Just follow up very briefly, I think there's a huge market for testing of drugs with potentially teratogenic impact on embryo development that we know virtually nothing about. But if we could have that sort of developing embryos, we could do very high resolution studies of novel compounds to see if they impact naturally.
Yeah, I want to pick up on two threads that are already raised. So one was the intent question, the other one was the disabling of the embryo. I think it's Emily from the Heritage Foundation, you raised that. So I think these kind of come into play here. I think the term stem cell-based embryo model, which is the preferred scientific term for this, doesn't quite capture other uses. They're not always made to just model development and study, normal or abnormal development, but people are actually using these as tools for future industrial or commercial use. One would be drug screening, and the other one would be, as a source for clinically relevant cells. I don't think if those entities would be appropriately called models, because you're not trying to necessarily model any like real human development. You're just trying to achieve some kind of engineering aim to then have some kind of application or assay for so I think we need a different term for those. But so the intent of like why you're creating this, is it modeling? Are you trying to recapitulate development, or are you just trying to get something very quick off the ground to do something with? So intent will, I think, matter in this interesting way, right? But getting back to the disabled point, I mean, when I talk to researchers who might be interested in developing like drug screens for, toxicology for the embryo, for which we have no data, what happens when women take these drugs when they're pregnant, what happens to the embryo. If you have, if you want to study particular systems, you should just make a very particular incomplete embryo model, make a lot of them, you can screen it, and there's no real question of, are you using real human life to do your drug screening or to get your clinically relevant cells? And to do that, what I would suggest is actually not getting starting off with something that you have to truncate this developmental potential, because that's kind of like disabling something that otherwise would have been healthy. I got into this whole debate with William Hurlbut in 2006 about alternuclear transfer. Do you actually need to, turn off CDX4 on the cell, before you do that? Or does just the cloning process make it an incompetent, entity, which I would argue that's what happens, and we know that historically, that it would just make it incompetent developmentally. So it wouldn't be, I would say, don't do something to the entity that you think could otherwise develop normally, because that invites the whole discussion of you're harming something that otherwise would have been healthy under other circumstances. I think you should do something to the cell line, because they said these are all iPS cells. Do something there so that when you put together your, whatever it is, your model, your thing, it never had the potential to begin with, right? So this is why I say incomplete, or something that nobody would question, is it a real embryo or not? So I think intention matters, what you do, how do you create the thing, do you disable it? I wouldn't go that route. I would say put together some entity that never had the potential from the very beginning. Like nobody had to disable anything. You just didn't have it. So that's the advice I would give. But I think you're absolutely right. There's this whole other interest. It's not development. It's not modeling disease. It's we want to use these things and get a lot of them. And for that work, I again, don't make them complete. Do something from the very beginning where they have no developmental potential.
And I'll say that tomorrow we'll have a paper on IVG, and we'll also have a paper on balancing and extrinsic reasons. Okay, so two people had questions next to each other, you two. That man with his hand up. And what we'll do, just to be clear, we're going to collect your questions, the two of you. We're going to get one, and then everybody in the panel can say one thing, and then we're done, right? So you can be responsive to them. You can ignore just one. Okay, then it's one. Then you can say two things in one question to make it fair, right? But there we go, and we'll be done. Go ahead, sir.
Josh Romero, Chapel Hill, North Carolina, and along with ASRM. My question is, post-Dobbs, we're seeing these personhood statutes or personhood decisions like popping up in several states. And we were talking about embryo storage and sort of regulations surrounding that storage. And particularly, one of the things that I find myself thinking about is states using these personhood decisions in order to create legislation to potentially force compassionate transfer of embryos, to force embryos being placed for adoption. And so this to me creates accessibility issues about gestational carriers and surrogacy. And one of the things that I wanted to ask you all about is, do you foresee any issues with how this affects individuals' due process rights or constitutional issues? And what does this say about our society if we were to force people to give up their embryos and their genetic information against their will?
So, small question to end. So you can either answer the small question or your last thought on the matter. We'll go down the line. Do you want to start?
Oh, me? Great, thanks, buddy.
You're welcome.
No, I mean, I think it's a fascinating question, and one of the concerns that people in the field, because the embryo personhood rules, I mean, those potential laws very quickly get to a place where, you think about what's in the best interests of the embryo, right? And is the best interests of the embryo always to be resulting in a birth, right? And so I think that you're asking a good question. Candidly, I think because it's so easy to see how quickly you get from embryo personhood to forced use for reproductive purposes of every embryo, I believe that's one of the reasons why these state laws haven't advanced very far and why it's been difficult to get consensus around them. But it's something that we really should be talking about as a society. Because I think if patients thought, as they walked in, as one of the things they had to consent to when they started a fertility journey was that if I have any extra embryos, I would be forced to give them to become an embryo donor for anyone, and every single embryo would need to be placed for pregnancy. I think it would really limit people's desire to begin a fertility journey.
Since Julia did a great job answering one side of the question, which I think is the side of how do we view this from the potential parent's perspective, right, of the embryo that is gestated, that they never intended to have gestated by another person. Let me take the flip side, which I think in a pronatalist regime, which we have now, it's really important to think about. It's what keeps me up at night in this area, frankly. And it reminds me, I think it's important to think of Judith Jarvis Thompson's article on the violinist. If you haven't read it, I think it's appropriate here because it really asks the question of whether there is ever a requirement or moral or legal, could be legal obligation to provide bodily life support, to bring life into the world, or to support another life that's already existing. And generally, we don't have those kinds of Good Samaritan statutes that require anyone to provide, for example, an organ to another person to keep them alive. But could we ever compel someone with a uterus to carry a pregnancy to term so that we don't have unclaimed embryos in a biobank is a really interesting question to think about in a pronatalist regime. Not enough time to answer it more thoroughly than that.
Insoo and Antonio, your last thoughts, go ahead.
Sure. So I've never been in a class where Glenn taught, but I kind of, from the way he ran this panel, I have an idea of what that would be like. It'd be a lot of fun. So since I'm in the law school, I will say there are some interpretations of the Due Process Clause of the 14th Amendment that would say that it's up to the individual to make their own personal decisions, religious, philosophical, or otherwise, of when they think life begins in the pre-implantation embryo. And I would say that I'm of the view that it shouldn't be up to the government to make that choice for people. And so I think I would hope that people stick to that principle, but clearly we are not sticking to that principle these days.
This is not really my topic, but I just want to go back to the industrialization thing, just to wrap back. Because I see both embryologists kind of want to talk about this advanced embryo testing, which is like the polygenic test, where this is happening now, right? This is right, the current moment's technology. You test the embryo sort of across all its genes, and you can get some kind of prediction of, type 1 diabetes risk, schizophrenia, height, intelligence, and so on. And so, people are really enthusiastic about this. We're going to have the perfect baby. Where it comes in with the production of sperm and eggs artificially from, a skin cell, could you make eggs and sperm? Is that you could make thousands of embryos, right? And you could choose the best ones. So you wouldn't be restricted to 4, you'd have 1,000. And now these folks down here will have to deal with like thousands of excess embryos. And not only that, but you could breed these embryos because you could do it again, right? You could derive more sperm and egg from those embryos and then cross them again. It's called wizzogenetics. And like the cattle breeding people would love to be able to do this. So that is coming. That is like the fantasy that is harbored, I would say, in certain corners of Silicon Valley, is to be able to produce millions of eggs and sperm, thousands of embryos, and pick the perfect baby.
Great. Well, no provocation there, so let's end with a round of applause. If you found this conversation interesting, it continues tomorrow in a more academic mode on live stream, but also think about signing up for our newsletter. You can sign up, I think, outside. We have a sign-up sheet outside the door, as well as our blog, Bill of Health. And thank you all. You've been a wonderful audience. We'll see more of you soon, we hope.
People want to do like drug screen testing also on the embryo models.